Hi, I'm Marc Stevens, author of Adventures in Legal Land, the soon-to-be-released Government Indicted, and host of the No Stay Project radio show. It's live every Saturday from 4 to 7 Eastern Standard Time on LRN.FM, and you can also hear it here. We're also on truthfrequencyradio.com. And I want to give an update, one of these Adventures in Legal Land success stories. This one is coming out of Florida. I had Raul email me. And what we'll do is let's just pull that up here. That's where we evidence that this was thrown out. Let me see. Where the hell is it? Oh, there it is. Oh, there it is. From the Hillsborough County Traffic Court. And this is in Florida. So what he writes to me, he says, "Hey, Mark, I tried to post this success story on the forum, but it keeps giving me an error message. My friend was being charged with Florida Statute 320.021. I think that's on there somewhere. Yeah, there it is. There it is. That's the code. A failure to register a motor vehicle. Oh my gosh, the horror, the horror. So it says, it is considered a criminal offense, and my friend wanted to fight it considering he has no criminal record. He was threatened with contempt at the arraignment, so he pled not guilty. So that's what they kind of do, you know. They threaten you with contempt to get their way. Because the psychopaths of society, the people who have no real talent, the people who can't use logic and reason to interact with others, they have to resort to things like violence, and contempt is definitely a tool of the cowardly psychopaths called judges, especially when you're dealing with something like a traffic court. And they're bad in Florida. They're bad all over, but Florida just seems to be a bit different level of psychopathy. He then came to me to assist him to minimize the damage. We immediately filed your motion to dismiss, which I have available at markstevens.net, along with the discovery and Brady request. The prosecutor eventually called my friend to make a deal. My friend rejected the deal and told the prosecutor that he would see him at the motion hearing. And I think that's great. I think it's fantastic. I think there's never take the plea or never make a deal website. That I agree. If these people want to charge you, give them hell. Never take the deal. Okay? Never take the deal. Especially in traffic, it doesn't make any sense. So my friend rejected the deal and told the prosecutor that he would see him at the motion hearing. So we filed a motion to dismiss, which, of course, I wrote is based on lack of evidence and that there's jurisdiction that the Constitution Code doesn't apply. And of course, that there's no valid cause of action. So when he showed up, it's amazing that in Florida that they even did a hearing, set a hearing for the motion, which is really good. Usually that's a good sign. If they set a hearing for the motion and just for the motion, not on the merits of the complaint or a trial, that's usually a good thing instead of just denying it outright on behalf of the prosecutor. He says, when my friend was called, the prosecutor immediately jumped up and declared Nolle Prosequi, Nolle Prosequi, which is Latin for "we shall no longer prosecute." Little information as trial. This is an entry made on the record by a prosecutor in a criminal case or a plaintiff in a civil case, stating he will no longer pursue the matter. In a criminal case, the statement is an admission that the charges cannot be proved or that evidence has demonstrated either innocence or a fatal flaw in the prosecutor's claim. An entry of Nolle Prosequi, or no prosecution, may be made at any time after charges are brought and before a verdict is returned or a plea entered. Most of the time, prosecutors need a judge's permission to nolo prosequi a case. And Raul says, it was over that fast. I'm attaching the paperwork provided by the clerk of the court. Thanks for your help. And that's Raul in Florida. So here we see it's not as detailed as some of them. It's more like a receipt. But nonetheless, this is evidence showing that it was thrown out. So you got the Hillsborough County Court. This is on, I guess that's July 19th, 2013. It was set for a trial for August 1st. But instead of having a trial, there it is. The prosecutor stood up in an open court, said, we shall no longer prosecute. There's the Nolle Prosequi. And it is signed by a judge. Make that, what you will, but it's signed by the judge. It seems to be completely legit. I'm glad to see all this fine and everything was crossed off. They chose not to. So this is just another congratulations. I don't even know Raul's friend's name, but I congratulations to the both of them for standing up to the man and not getting a ridiculous smear on your record or on your basically your reputation that you're a criminal because you did not give money and register your automobile with a gang of criminals. So congratulations for standing up to the man, and it's just more evidence. If you just stand up to them and you call them on their bluff, that the idea that their constitution and laws or regulations or statutes, whatever you want to call it, like 320, whatever it happens to be, there's no evidence whatsoever that they apply to you. Just challenge them on that. Why else would this man have, after being challenged by a motion, at a motion hearing, decide not to prosecute anymore? Had he had evidence the Constitution and Code applied, he would have just presented it. So, again, congratulations, Raul and his friend. I'm going to get this posted. It'll be very soon. It'll be here under the success stories on markstevens.net.